we'll begin with State of Ohio versus John, you just make me have to say that name again. Pustelniak. Each party will have 15 minutes to present its arguments. Appellant may reserve up to 5 minutes for rebuttal. You just let me know when you come up here how much time you want to reserve. I'll try to watch the clock for you. The arguments are being visually and audibly recorded to be posted online. Please keep your voices up and remain behind the podium. We have read your briefs and we are ready to begin.
Just to clarify quickly, because there's cross appeals, do you want us?
I want you to address everything.
Everything, okay.
And the reality is you have 5 minutes for rebuttal.
Right,
so
okay.
I guess you have that.
I'll need my 5 minutes.
Okay.
May it please the court, Giovanna Bremke on behalf of Mr. Pustelniak. Again, there are cross appeals in this case. I'll focus first on the sentencing issue that the state has raised. All of the facts and procedurally very complex in this case, so I won't get into it too much, but if there are questions, let me know. All of the charges, and they were modified and renumbered, and some were dismissed, but they all relate back to an October 5th, 2017 police chase through multiple jurisdictions, starting in North Ridgeville, going to Avon, and then ending in Elyria, back to North Ridgeville and ending in Elyria. There are 2 different cases here that were consolidated. They're both 2017 cases and then consolidated to this appeal. The sentencing issue there were multiple failure to comply charges, which the trial court merged for purposes of sentencing. There's 4 of them. And the merger analysis is found on page 579 of the transcript. Essentially, again, to get into the facts a little bit more, there was a vehicle stolen from Crocker Park in Westlake outside of this jurisdiction, again, something that's addressed in my argument later. And the individual was stopped in North Ridgeville, right on the Avon border, by a North Ridgeville officer. Did stop, but then took off. Went through Avon. Avon was having an annual homecoming parade. Went through that homecoming parade. Went through in reverse. So at the end of the homecoming parade, came out at the beginning of the homecoming parade, back into North Ridgeville, where an officer who was aware of the chase had noticed him, and then went and eventually was reprimanded in Elyria. The court, in doing the merger analysis, references the Johnson case, which is a 2010 case, but tracks with the Ruff case, which is a more recent 2015 case, for purposes of the factors, the 3 factors. 1, were they dissimilar in import or significance? 2, were they committed separately? And 3, were they committed with separate animus or motivation? And the court does, and I quote the entire thing in my brief, the court does a very thorough analysis of these 3 factors. And also notes that the defendant's conduct should be the focus of the analysis, which is Ruff, paragraph 30, but also cited by this court's analysis. And the court notes, again, that acknowledges that it's a difficult analysis and that other courts might find it differently, but he's taking into consideration the defendant's conduct, and also notes that the Supreme Court has noted that differing results between courts are permissible because, and he says, another court might find differently, but again, I'm examining the conduct of the defendant, and it's a subjective test. And so again, back to those 3 factors. The first was whether they were dissimilar, and what the court found was that Mr. Pustelniak fled to different routes in different jurisdictions without any significant differences. Again, it was one fleeing at that point. There was never a break in that escape. The second was that the conduct did not cease for a appreciable period of time, and that's what the court says as far as the second factor. and that's whether they were committed separately. And the third being whether it was a different motivation. And again, I think that this is probably the most clear factor, that the motivation was to escape, and that was the motivation throughout the entire chase at that point.
Let me ask you something, counsel. If someone were to burglarize 3 different houses along the block, isn't that person's motivation to steal? I mean, you still have the same motivation, right?
Right, but again, taking into consideration the 3 factors. So in that case, the third factor, there might be different motivations, but the other factors may fall into place. So in that case, all 3 factors might not come into
Let's
play.
say I did it 1, 2, 3, just one
Right.
after the next. I was having a great day.
Right. Again, I think in that case, you can maybe distinguish it in saying that there was a break in time. This court said there was no break. There was no stopping of the vehicle. It ran from the time it was stopped in North Ridgeville to the time it was reprimanded in Elyria, with no appreciable period of time. Again, in that case, maybe saying, well, I got in my car and I drove to the next house and I burglarized that house. That could be, a distinction in that case. And the 2 cases that are 9th district cases, and I think you're well aware of them, the Denby case and the Hunter case. And I'm very familiar with the Denby case, and in those 2 cases, and most of the case law in this area relates to violent crimes, and you can distinguish the different harm. And also, the elements of that offense, there's a harm element. So in Denby, it was murder and felonious assault, in which, and same thing with Hunter, I think they were basically identical facts, but reversed inside the house and outside the house. There was harm inside the house and then murder outside, and vice versa in those 2 cases. And harm being an element of that offense. These failure to comply, and what the state's going to argue is that there's separate harm, and that goes to, I believe, the first factor, that there can be distinguishable harm. In those cases, that harm is an element of the offense. And same thing there was a case, arson case, again, the Harris case, in which there was a mother and firefighters, and they were saying there's distinguishable harm between the harm to the mother and the harm to the firefighters. And in this case, it was the same harm, the same motivation, the same chase throughout multiple jurisdictions. And for that reason, it should be merged.
What is in the record about that last attempt to stop, the one that, wherein the defendant's car's in the gas station parking lot?
Right, so that's important because, again, I believe it was Officer Larkin, and I'm going to point to page 210 of the transcript. And he testifies that he purposely positioned himself there because he knew the probable route for somebody going outside of that Avon area would be to come back through this road where he was stationed. So again, when you're talking the continuation of that chase, that officer is still looking for him and predicting his future conduct in going back into that second jurisdiction to, so it didn't cease for an appreciable period of time, which is what the court had held.
Well, was the defendant's car stopped in the parking lot?
I believe that he had testified that he saw him and he was in the vehicle, and that he took off shortly after that. So for how long he had stopped, I don't know. I don't know that there's any testimony to that, and I don't know that the officer would know that because when he had saw him, then he had taken off again.
Is there any significance to the fact that the failure to comply were 2 different cases? And the jury found them guilty in 2 different cases?
Again, I believe the reason that they were filed in 2 different cases were because of the jurisdiction issue. But once they were indicted in this case, the county, and as far as the failure to comply, there was testimony that those had happened in Lorain County. That I had raised the argument that theft, there wasn't there wasn't venue, again, in my portion, because that happened in Carroll County and Cracker Park, but the failure to comply all happened in Lorain County, and certainly the county police and the county prosecutor would have jurisdiction to prosecute those and run those together when they were indicted. There's also, again, when we're talking about that officer positioning himself back in North Ridgeville, and there's a cite to a Hunter case, which is a 9th district case, but Hunter cites to Craig, which is a 4th district case, in which they talk about a line of distinction or a break in a continuum of events. And again, when we're talking about that officer positioning himself, that wasn't a break in the continuum of events. It was the probable route that this individual would go after leaving that parade route, and that officer knew that and was still pursuing him from the time that North Ridgeville department was the very first department that had pulled over the car, and then knew again that he would go back into that jurisdiction, and it was a continuation of that jurisdiction trying to apprehend the individual.
You're just under your 5 minutes.
Okay, I'm going to reserve the rest of my time.
Good morning, judges. May I please report for the state of Ohio, Brian Murphy, Lorain County Prosecutor's Office. Before I start, I do want to note a error that I made in my brief as I reviewed it the other day. On page 22, the last paragraph starts with a reference to a Harris case. It should be Hunter. I then go on to discuss the Hunter case at that point. In reading the briefs, you may not have caught that. I do discuss both Harris and Hunter. I just had inadvertently wrote Harris where it should have been Hunter there on page 22. The state suggested to this court that really this case is about a 3-act story. Appellant's counsel described this case as a police chase through multiple jurisdictions. The state suggests to you that this was really multiple police chases involving really 3 cities in a single county, that being Lorain. What quite possibly, I think, colored the trial court's analysis of this case is a bit of a twist when it came to sentencing and the unusual requirement upon courts when a defendant is sentenced for multiple failure to comply convictions. And that's that the prison terms must be served consecutively. But what the law says in Williams, the Ohio Supreme Court said, when a court considers the issue of allied offenses, quote, the question is not whether a particular sentence is justified, but whether the defendant may be sentenced upon all the offenses. The allied offenses statute, of course, in 2941.25 really is elucidated for reviewing courts in the Supreme Court's opinion in Ruff, looking at dissimilar import, whether the offenses are separately committed and whether they're committed with separate animus or purpose and immediate motive. Appellant's counsel referred to offense elements such as harm. That's not what this court considers, though, are the offense elements, but just the defendant's general conduct in committing the offenses. And need only find that one of the 3 factors applies, that being the dissimilar import, whether they were separately committed and whether they were committed with separate animus. If you find one of those, then it is permissible to separately punish the offenses. And if you find one of those, in this case, then the trial court sentence from the state's view was illegal and contrary to law. Judge Schaefer, as you pointed out, there were 2 different cases, and the state's perspective, that goes toward the double jeopardy and merger analysis, which really was kind of the forefront before allied offenses of similar import became the term synonymous with whether we're going to punish multiple offenses, because what the double jeopardy clause prohibits are multiple punishments for the same offense, and deals with merger, which is taking one crime that includes component elements of other crimes and merging them into the major crime. Here there is no major crime, such as, let's say, under certain circumstances, rape and kidnapping. Here there are three separate offenses that don't even call for any consideration of whether there's jeopardy, a double jeopardy issue, or merger. They're not prescribing different offenses here. The separate failure to comply. The three separate third-degree felony failure to comply didn't prescribe the same conduct. It prohibited three different failure to comply offenses, 3 times fleeing from the police, as we'll show you. Defense counsel's allied offenses analysis, I suggest this court was non-existent. Frankly, the trial court probably didn't even need to reach an analysis of the allied offense issue based on what defense counsel presented to it. Defense counsel said it was one continuous course of conduct that doesn't even examine the factors that the Supreme Court set forth in Ruff. The trial court's analysis, according to appellant's counsel, when she was standing before it, was thorough. State suggests that it was maybe elongated, yes, but I don't know that I'd describe it as thorough. I think the first problem happens in that the court referenced that Johnson case, which may describe why, or may explain why its dissimilar import analysis was applied the wrong legal standard. The trial court said that the fleeing was similar conduct without a significant difference. Well, Ruff says we just look at the conduct of the defendant in determining whether they're allied offenses. So to say it's similar conduct doesn't really answer the question of whether there was separate harm or separate victims. In discussing the separate victims prong of the dissimilar import, appellant's counsel was talking about the harm element, and I refer you back to the Harris case, which dealt with aggravated arson charges. Aggravated arson charges, there were at least 2 of them, one for the defendant's mother, one for the firefighters who responded, for obvious reasons. The aggravated arson, much like the failure to comply statute that Mr. Pustelniak was charged under and convicted of, references creating a substantial risk of serious physical harm to, in the Harris case, the mother and firefighters. Here, the creating a substantial risk of serious physical harm was three different events, 3 different distinct separate sets of people. The first one, after Mr. Pustelniak fled from Officer Lorain, he's going down Mills Road, he's going down Stony Ridge, and that's one group of people. Mr. Pustelniak was swerving around them, going off the road. He's going the wrong way on what's just a 2-lane road, one going north, one going south. He's in the wrong lane. This is all happening at about 6:30 on a Friday evening. That's at the end of spring, the summer's getting started. So those are different victims. separate people exposed to a substantial risk of serious physical harm. The Detective Bergen, then in Avon. And then finally, a whole new subset of, or a whole new set of people as Mr. Pustelniak fled from the second officer in North Ridgeville, Officer Larkin, and into Elyria. Officer Larkin saying he had never been so scared during a traffic pursuit in his entire career, which I think at that point had extended more than 20 years. So whether there's an aspect of whether anyone was harmed under dissimilar import, I think really to look at it is whether there were victims who potentially could have been harmed, the way the charge that Mr. Pustelniak was actually convicted of and that the trial court was considering for allied offenses analysis. Whether they were separately committed, the trial court said maybe they were, maybe they weren't, but his course of conduct did not cease for any appreciable period of time. There was no true separate stopping or starting, is what the trial court said. The record doesn't reflect that. What Mr. Pustelniak did, he stopped in Avon. Detective Bergen told him to stop. Another officer was following the car and said, it appeared to me that he stopped for Detective Bergen. That's no different than what Mr. Pustelniak did with Officer Lorain in North Ridgeville. He stopped when he was told to, and then he took off. He stopped for Detective Bergen, and then he took off. And then he goes to a gas station in North Ridgeville. He's in a parking lot. He's no longer doing 35 miles per hour or 60 miles per hour. He's in a gas station parking lot. By the way, Officer Larkin was not positioned or stationed waiting for him. The record says that Officer Larkin drove up to a stoplight, was approaching a stoplight, when he saw a car that matched the description. Well, he's not waiting for him. Mr. Pustelniak had gotten off the road and into a gas station parking lot. This is the interrupting events that creates the distinct line of demarcation that this court has set forth in several cases, including Hunter and Demi.
Would going off the road and crashing into a fence be another line of demarcation?
Well, I don't believe so, Your Honor. It's still, at that point, that was Officer Lorain still chasing him. I don't think so. Officer Lorain was still pursuing at that time. The fact that there was one trial in the same general jurisdiction of Lorain County also, I think, could have clouded this analysis, because I'd suggest to this court that if what happened first was in Lorain County and next what happened in Avon or North Ridgeville the second time was over in Erie or Sandusky or Cuyahoga County, there would be no problem with charging him twice for those failure to comply and convicting him twice and imposing 2 separate prison terms. And it would be the same if he were fleeing in the state of Ohio and just drove straight into Indiana, Pennsylvania, or Michigan. The 2 separate states or local jurisdictions could also charge him. These were 3 distinct stops and starts, no different than a single sexual offense in which an individual is charged with vaginal and oral rapes of another person. And this court said in Frederick, a 2014 Ohio 5537 case, 2014 Ohio 5537, multiple instances of sexual assault that occur very, very close in time can be punished separately. The separate animus, the separate purpose or motive, generally yes, it was to flee police. However, the specific, it says immediate motive. What was Mr. Pustelniak's immediate motive? It was to get away from, it was to first get away from Officer Lorain. He was successful. He then stopped the car for Detective Bergen. And what did he do? He fled again, hitting Detective Bergen. The car struck him. There were no convictions, but it did strike him, according to the record. So he's fleeing Detective Bergen's stop now. He's successful there. He gets to a gas station, pulls off the road, he's in the parking lot. Our Officer Larkin tries to pull him over, and Mr. Pustelniak flees from him. These are 3 separate purposes. The purpose was to avoid 3 separate officers from 2 separate jurisdictions at 3 separate distinct times. The trial court, just regarding the separate animus, is he didn't intend to harm or injure anybody. Again, that's the wrong legal standard. That was the first analysis that should have been done, the dissimilar import. was whether he wanted to harm or injure anybody. The purpose or the motive, harm with regard to the purpose for committing a failure to comply is really irrelevant. So when we're looking at failure to comply offense, whether he intended, Mr. Pustelniak intended to harm anybody, is really irrelevant under the separate animus arm of the allied offenses analysis. If the court doesn't have any questions on the state's cross appeal, I just generally point out two things with regard to the direct appeal that Mr. Pustelniak filed. The first being with regard to venue, that it was never raised in the trial court, the venue, which would indicate that the issue was waived. Secondly, that although the record doesn't reflect that the car was taken, the record reflects that the victim, the owner of the car, last saw the car at about 6:10. Officer Lorain said he pulled the car over at about 6:30. Westlake into North Ridgeville, that it was not unreasonable to believe that Mr. Pustelniak, based on those circumstances, circumstantially had stolen the car in Westlake and gone into North Ridgeville where it was pulled over.
Your time's up.
Okay, thank you, judges. We'd ask that you affirm the convictions and especially the convictions, but then remand that the sentences can be imposed on those 2 counts only. Thank you.
Good morning again. I wanted to point out a few things just to address what the state had said. One, the Harris case, and again, it's a 9th district case out of this court. The harm, the sentences were not merged, and the harm was to the mother and to the firefighters in this case. And again, there was talk about potential harm. That's not what the analysis says. It doesn't say potential harm. It says separate harm, not potential harm. And the only argument for harm would be to the only argument that was raised at the trial court and in the briefs is that there was harm to the officers. In the Harris case, I think it's significant because there wasn't a separate charge and a separate sentence for each firefighter. There was multiple firefighters. Certainly one firefighter did not extinguish a large fire like that. And there was only 2 separate sentences based on the mother and then the firefighters as a group. So I think that's a good distinction there. There's also talk that Officer Larkin, again, we're talking, he's the officer that when the individual went back into North Ridgeville, he was, and I may have mischaracterized it as waiting for him. But again, and I believe the transcript was 210, but he was predicting his behavior and going back into the jurisdiction. And he wasn't just, he was on patrol, saw the individual and had said, oh, well, there's also a chase going on. He was explicitly, and the record's very clear, that he was going to that area to look for the car that had fled. So it was definitely that he was a continuation of that same chase. He was still actively looking for that individual. And there was also talk about an immediate motive as opposed to the just motivation in general. And again, I think that's reading into the analysis, and that's not necessarily what the analysis says. It says, what's the motivation? And again, the court is clear that the motivation here is, the trial court in doing its analysis is to escape, and that it had continued that escape, and that was the motivation. I will address briefly my direct appeal, and that's the sufficiency and the manifest weight. There is the issue about venue in the sufficiency. The theft was in Crocker Park, obviously outside of this jurisdiction that's in Westlake. And as far as manifest weight, the entire trial surrounded around identification. And if you look at, and I'm going to name Officer Fishback, transcript 303, Officer Barton, transcript 313, Officer Taft, transcript 348, Officer Ruppel, transcript 367, Officer Sullivan, transcript 379, all of those Avon police officers that say, I cannot identify this individual. North Ridgeville, Officer Lorain, who's the very initial officer on the that pulled over Mr. Pustelniak, says he got to the vehicle, but in his transcript 194, he could not see inside the vehicle. There's no surveillance. Again, there's 4 jurisdictions and a parade route, which the state characterizes as having thousands of people. There's no cell phone video. There's no surveillance video. There's no body cam videos. Nothing to that goes back to the identification of Mr. Pustelniak. There's also talk of a twin brother, and all of that again goes to the identification and the convictions against the manifest weight of the evidence. The sufficiency, again, in inducing panic, there was a case, the Campbell case, in which the officer showed up to the a house on report of a domestic violence, and there was multiple officers. The conviction and it was reversed, saying that those officers, even though they waited for a good amount of time for this individual to come out, and he didn't come out, that it didn't interrupt their duty. And again, I would ask that you reverse on my direct appeal and in the alternative, sustain on the merger analysis.
All right, thank you both for your presentations. The court will take the matter under advisement and will issue a written decision, which will be mailed to both sides as well as posted on our website, and that will